Hello, everyone. We're having a fellowship tonight. It's what? It's the 26th of the 8th month, I believe, on our creator's calendar. I might be off on a day. I apologize. It's late. But it is also the 9th of the 11th month on the Gregorian calendar, just for comparison's sake. And we are going over tonight this constitutional law brief by Carl Miller, who he has since passed, I believe, but he was a common law lawyer for a long time. He's a Vietnam vet, and he was actually part of Operation Blue Book, where he was taken aside by the military and trained in the Constitution and how to help protect the usurpations that were happening in our country. And he defended many people in courts of law and got them protected and their rights upheld from these usurpations that are happening more and more. A lot of people don't know why it is, and we'll get into that some other time, but this right here, this brief will allow us, anyone, to support and defend any right that you have. So without further ado, we'll go ahead and read it. This is Constitutional Law by Carl Miller. Your Constitution is an ironclad contract enforceable in a court of law. And this contract limits the government, is what we're going to see. So right here, U.S. Constitution, Article 6, Clause 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, meaning in agreement with it, and all treaties made or which shall be made under the authority of the United States, meaning it has to be under their jurisdiction, what they're allowed to do. It says, shall be the supreme law of the land, and judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Meaning the government, when the documents were written, as it was written then, everything that they had in there, that was the supreme law. And there's nothing that could be written afterwards in the Constitution or in any state constitution or any legislator's law or in any judicial ruling that can gainsay that as the supreme law. It would be void. That's the supremacy clause. This is the Bill of Rights, Article 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. There's a lot of miscomprehensions on this. People have commonly talked about separation of church and state, or assembly and state, if you will, which, as you can see, it doesn't say that anywhere in here. But what this is supposed to do is this protects us from the government. Nobody can tell you that you can't pray. No one can tell you how you can observe your religion, and they can't stop you from doing so. This is why they openly pray in public. They used to do it all the time. They prayed in schools until they illegally, unlawfully rather, made judicial rulings to take that out. But it's all color of law. It's all void. Bill of Rights, Article 2, it says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There's no stipulations, there's no conditions, there's nothing, there is no law they can make that it has any validity. All of it's color of law and void from enactment. We just don't know better. And the reason why they get away with things is because they don't pass these laws as applicable to men. They have it applicable to their citizens and their corporate fictions that they've created. They don't tell people that there's a difference between them. And then people, not knowing better, think that that applies to them. And so they criminally use this against us. Article 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That means all this color of law, well, if I see something in his car, I can take him out and search it. Or if I think I feel threatened, I can take his stuff. It's all unlawful. It's a violation of our rights, and because we don't know better, they get away with it. It shall not be violated. Your houses, papers, effects, okay, and your person. And this is against unreasonable searches and seizures, meaning any detainment. Anytime they take you, especially if you're traveling in your car and they have you sit there on the side of the road for 3 hours, that's a seizure of your person and property. That's unlawful. They can actually be punished for that if you do the right methods. Like I was saying, you can send them a letter. And there's a gentleman called, he's got a ministry called urlaw.org. And he does a great number of videos on it. He's far more experienced in it than I am. urlaw.org. He talks about how you send them a letter and you can do these things to try to get them to leave you alone or to assert your rights when you've been violated. There's other means for remedy here. But anytime there's a violation of your rights, there's a remedy. You'll see that in just a minute. It says, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. They can't just do a carte blanche, blank statement, search everything you have and look for stuff. It has to be specific, and it has to be supported by an oath or affirmation. Someone has to swear that they believe that you're involved in a crime. Article 5, and that means that if they're wrong, they're liable to reparation for perjury, by the way. That goes along with scripture where you're allowed to face your accuser. So Article 5 says, no person shall be held to answer for a capital or otherwise infamous crime, meaning a crime that imprisons you or causes a death sentence. Any incarceration, right? Unless on a presentment or indictment of a grand jury. And there is no grand jury in the state of Washington, I've been told. I'm not sure or certain there's grand juries functioning in any capacity outside of the federal through their court systems that they have. But the grand jury is the people's responsibility, which we really need to learn about it and get it up and going again. But it says, except in cases arising in the land or naval forces or in the militia, when in actual service, in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. That's the right to remain silent that they talk about, right? You don't have to be a witness against yourself. Nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Article 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, meaning they can't do it in secret. You're allowed to have a public trial. And a common law trial, they don't get the right to decide what evidence is presented and what evidence is not. That's the wrong court system. That's the civil city law, Roman canon law. That's Satan's government, where they get to make the rules. The judge can arbitrarily change rules. I'm not kidding. They can change the rules. There was a lady who just got fined $5,000 for not wearing a mask because it was requested of her by the judge and she did not want to. It wasn't asked, it wasn't demanded, it wasn't said you must. They played word games and then they tried to punish her. So they're allowed to do crazy things because we don't know our rights and they get away with it. But in all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And as we go through the Citizens Rule Book, you'll see the importance of a jury. The jury is supposed to try the facts of the case and the laws in question. So if it's a statute, then, and they're trying to say it applies to a man, anyone on the jury can say that's not common law, that's not constitutional, not guilty, and that man goes free. And that's how we protect people in this country from arbitrary law. But since the 1850s, they stopped teaching the jury that they have a right to judge the law and the facts. However, we just have to do so. They can say what they want, but you're allowed to say not guilty, period. And it is the obligation of everyone that's a jurist to do so. But it says, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him. This is important. If you get a traffic ticket based on a camera, you call that camera into witness against you. They can't do it. That doesn't stick. It's literally that simple. But because people don't know that this is a requirement that they can rely on, they don't ask for it. You see, this is why it says, my people are destroyed for lack of knowledge. We don't know the scriptures and we don't know how it applies in reality, but it's literally the government, the law that functions in this country. So, and to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is an important term. You can actually have someone as a friend stand in your place to be your assistance of counsel, and you don't even have to show up. I didn't know that, but it's actually true under common law. And under common law, you never want a lawyer an attorney. Assistance of counsel is what we're given in the Constitution, and anyone can do that. You don't have to be an attorney. I would recommend you never get an attorney, because bar attorneys are, for one, it's a title of nobility, and they are first and foremost subservient to the court and to the ones that they hold fealty to. But their whole point is to run a process and to help them enforce the statutes that are not under common law. It's two different jurisdictions, really. But Bill of Rights, Article 7, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Article 8. This just means, this protects everyone's right to trial by jury if any damages, if the controversy is exceeding $20. And I'd always encourage everyone, regardless of any circumstances whatsoever, if you must go to court, always demand your trial by jury, because it's the jury that protects us. So it says, Article 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, which happens all the time, but because we don't tell them they're not allowed to, they do so, right? Article 9, The enumeration in the Constitution of certain rights shall not be construed to deny or disparage the others retained by the people. And it goes right in hand with this number 10 here. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This is a 1-2 punch that protects us against any usurpation. This says that any right, written or not, still belongs to us and we retain them. And this one says that anything that we didn't delegate to them, to the federal government or to the state, is reserved by the people, period. It doesn't say they get to define our rights or tell us how many we have or what they are. We get to decide what our rights are. We get to tell them what we're allowed to do. The only thing that you're not allowed to do is harm somebody. You can't damage their person, you can't damage their property, and you can't damage their character without having a remedy. And these are all according to common law. It's what scripture proves. Laches is a canon law or municipal law, rather a Roman law statute, court rulings, okay? I don't know if this applies to constitutional common law, but the idea is the doctrine of laches is based on the maxim that equity aids the vigilant and not those who slumber on their rights. Neglect or omission to do what one should do as warrants presumption that one has abandoned right or claim. So it's again a presumption. That is not common law. They might say it is, but to presume or to assume things is satanic. Common law is scripture, and scripture says to prove all things. But right here, a failure to do something which should be done, or to claim or enforce a right at a proper time. Basically, if you don't claim a right, you don't get it. If someone violates your right, you have to stand up and say, don't do that, or you've agreed to it. That's how that works, though. This is a court ruling from 1803 that's foundational, okay? It's Marbury versus Madison. This would be James Madison when he was Secretary of State. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical. For certainly the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, that's the TSA, that's any gun laws. It would bear no obligation to obey, that's driver's licenses or hunting licenses or anything else where they demand a privilege from a right. It would purport to settle as if it had never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. Meaning it's our duty to disobey unlawful legislation. It operates as a near nullity or fiction of law. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional by Marbury versus Madison. Then Shepard's Citations, a group of reporters that go through and keep track of all court cases that have come before the courts, especially the Supreme Court, and they clarify before the court all the cases. All cases which have cited Marbury versus Madison case to the Supreme Court has not ever been overturned, and there's been hundreds and hundreds of them. This has been around since 1803. This court case has never been overturned. It's the supreme law of the land. Anything that's contrary to the Constitution, void. Now, how they get around that, just so you know, they don't ratify these and try to make them law in that capacity. They make them statutes that are applicable for employees of the government or non-citizens and others that are under their jurisdiction in their territories. And then they get us to believe that it actually applies to you when it doesn't. Title 5, U.S. Code Section 556D, Section 557, and Section 706. Courts lose jurisdiction if they do not follow due process of law. That's vital to keep in mind. Title 18, U.S. Code Section 2381. In the presence of two or more witnesses, which is why you should never go to one of their courts alone, right? In the presence of two or more witnesses of the same overt act, or in an open court of law, if it's a court of record, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason, which has a $10,000 fine, 10-year penalty in jail, or it's a death sentence. They also have other statutes with other penalties under treason that you could look up, but I'm not really concerned about that. This is from the American jurisprudence books, okay? This is the jurisprudence for our country, for common law. This is book 16, specifically constitutional law section, okay? This would be 16 AM jurisprudence second, or 2D, section 97. It says, then a constitution should receive a literal interpretation in favor of the citizen, is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. When you work and someone pays you, you've gotten compensation for services rendered. That's not an income that's taxable by a government lawfully, because that's your property, and it's their job to protect your property, not take it from you. They even tell us to our face that the taxes are voluntary. But when you try, they'll attack that corporate fiction and make you think that you're it to try to get you to do it, because we don't know better. But you literally just have to stand on the fact that you're a man and not contract with them. It says any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. You are the beneficiary of the U.S. Constitution. Section 98, and this is about laws or legislation that they have passed or any emergency acts they might try to enforce. A mandate is less than a law, so pay attention here. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or states' constitutions, public emergency, such as economic depression, for especially liberal construction of constitutional powers, and it has been declared that because of national emergency, it is the policy of the courts in times of national peril so liberally to construe their special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution. To sum that up, the only thing that really applies to us that we need to know is No emergency has just cause to suppress the Constitution. They cannot make any excuse. Doesn't matter what's going on. Our government was formed in a state of emergency. All right. And there is no emergency that can make our government cease to function the way it's supposed to. That's a safeguard that's protected. Section 114. As to the construction with reference to common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destruction of the abatement of nuances by summary proceedings, and was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in a sense of a national customary law, as distinguished from the common law of England, meaning they're one and the same, adopted in the several states, in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood or comprehended. And we'll look sometime later, but I'll show you the common law. You can date it all the way back to 510 BC, where they were keeping the statutes in scripture in Britain. By the time of Alfred the Great, when he codified the laws, Alfred's dooms literally started with the 10 Commandments and then the right rulings in scripture, and went on to the other things of his laws that had come about through time and inclination. But in that order, it was common law was scripture first. Excuse me. So section 117 of the same, it says, various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in and determining its meaning. As previously noted, however, such intrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument or the document itself, which is what they call an instrument in legalese. So when it says that the right of the people to keep and bear arms shall not be infringed, you can't look elsewhere to try to determine how that can be applied. It means it shall not be infringed. And that's any right. That's any liberty that you have, by the way. Section 155. Since the Constitution is intended for the observance of the judiciary, as well as other departments of government, and the judges are sworn to support its provisions, you notice none of this says that it was intended for observance by the people, because it wasn't limits to us. That's the point. Let me start over. It says, since the Constitution is intended for the observance of the judiciary, as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. So it doesn't matter if there is this coronavirus, if you want to call it that. It's a bioweapon. It's now known. It's going to be known in courts soon. But it doesn't matter if there was a real plague or if there's any type of emergency. No one can deny you the right to do as you will if you're not physically harming them, they can't tell you what to do. It doesn't matter what their opinion is, it's irrespective of the consequences. They don't have a right to tell you how to protect yourself, right? Thus, it is said that the courts should be and are alert to enforce the provisions of the United States Constitution and guard against the infringement by legislative fiat or otherwise in accordance with these basic principles. The rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute another rule in a or the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. So again, this is just reiterating, if there is another law or a statute that's contrary to the Constitution, it's the duty of the judge to side with the Constitution. They don't get to make their own choice. Section 177. Declaratory judgments actions have often been utilized to test the constitutionality of a statute in government practices. The Uniform Declaratory Judgment Act makes it's supposed to be specific provisions of the determination of construction or validity of statutes and municipal ordinances by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statute and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked frequently as a means of saying of the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. Meaning you can ask to have any state or federal statute be declared unconstitutional by a federal judge, only one, but you cannot have them enforce the statute to be applied by a single judge. You have to have a tribunal, as it was reading above. However, if you're in a federal court, you can say, I want a declaratory judgment that law is unconstitutional based on such and such, and you have to declare it in my favor. Because if you remember, you go right here, it says that they have to construe it in a literal interpretation in the favor of the citizen, period. And then you can declare that what they did is unconstitutional because it violates your right. And you are the one that retain your right. You remember, it's in the Constitution. You just have to tell them it's your right. And when you do so, they have to abide by it because that's the law. But we don't get told that that is how things work. So to sum up what this means, right? No one is bound to obey an unconstitutional law. You can demand a declaratory judgment. And if they deny you a declaratory judgment or say no, they've just committed treason in an open court. That's how that works, but we have to enforce it. And just so you know, it's under the legislation for what Congress is allowed to do. They're supposed to, it's under Section 8, Clause 15. I think it's Article 1. But they're supposed to legislate for the calling forth of the militia, which they have not done. We have no laws or no legislation about how to call forth the militia that I'm aware of. They failed to do what they're supposed to. But the purpose of that is threefold. The militia's job, when it's called forth, is to enforce the law. That's our job. The militia is every able-bodied man that can hold a weapon. And it's the militia's job to enforce the law, to repel invasions, and to suppress insurrections. And we're not able to do any of those because we're not taught this stuff. But this is what that Tactical Civics and others are trying to do, and I'm learning about it as well. Section 255. In all instances where the court exercised its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. So the Brady Act or any legislation that infringes on your unalienable right to bear arms is irreconcilable to the Constitution, and it can be declared void. It's already void. It is no law that applies to a man, and all we have to do is not obey it. It says, thus a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. Anything the TSA is doing is in violation of they're violating your right to be secure in your person and your effects without search and seizure. But because we're not standing for that, it's allowed to happen. And it's an egregious violation of our rights. A clear incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as to the constitutionality should be resolved in favor of the constitutionality and the beneficiary, which, if you remember, you are the beneficiary. So it has to be ruled in your favor. Section 256. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never had been passed. Such a statute, not a mandate, but actual stuff passed by legislation, mandates are inferior to these and have less authority, which is none to begin with. But here, such a statute lives a question that is purports to settle just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. It's not voidable, it's void. It's already not law. The general principles follows that it imposes no duty, confers no rights, creates no office, bestows no power of authority on anyone. So it's a bunch of criminals frisking people, affords no protection, and justifies no acts performed under it. So any officer violating your rights by searching your car when he doesn't have a sworn affidavit or a sworn testimony and a warrant to do so, he's violating your rights, and there's no justification. It's right here, but we don't know these things and we just let it happen. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where, I read that again. No, I didn't. And where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the law or of the prior law will usually fall with it and will not be permitted to operate as repealing such prior law. Meaning they can't change it. The original law will stand. Okay. The general principle stated above applies to the Constitution as well as the laws of the several states insofar as they are repugnant to the Constitution and laws of the United States. So again, it says it even applies to the Constitution, both the federal Constitution and the states' constitutions. And I'll give you two examples. In the federal Constitution, you have the enactment of the 14th Amendment, where they try to make every American a citizen with privileges, which is under their jurisdiction, instead of a citizen, capital letter C, with unalienable rights. That is an inferior law that's void because it's trying to usurp what we've already been given. It actually was meant to try to, they say, free the blacks, but it really was meant to enslave us all. And if they really wanted to free everyone that was not white, the only legislation they had to put through is that the common law and the Constitution, or the rights of the people, will not be denied based on color, or the common law will not be denied based on race, period. And then it would be for everyone, no exceptions. But that's not what they did. And what they did was unconstitutional. So it's automatically void. We just have to stop following it. One for state constitutions, I'll give you one more closer to home for me. The Washington State Constitution, the original that was made by the people, that the people said only one that's approved by us will be accepted by us, was given to the state legislators, and then they put that aside and passed their own. So the one they pass is void, even the whole thing. The one that was original is the one that's established by the people that we need to enforce. But even in that document, they said that the Second Amendment, the right of the people to keep and bear arms, shall not be infringed. But that doesn't mean they can go around carrying it out or concealing weapons as they please, or concealing arms as they please, or something to that effect, which that's not the right. The state constitution does not have the right to infringe upon what's guaranteed and protected already. It shall not be infringed. So that state, the part of that constitution, is void. We can have our arms. There is no infringement. And it's true for every state in the union. There's nowhere you can go in our country, on our land, where they can deny you the right, because that's the law. So that's two examples. There's plenty more, right? But we'll continue. Section 257. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justly justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested of status of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature, both of the statute and of its previous application demand examination. It has been said that an all-inclusive statement of the principle of absolute retroactive inviolability cannot be justified. An unconstitutional statute is not necessarily a nullity. It may have an indeterminate consequences binding on the people. And this just means that when they try to pass something and it takes things from us, if it's gone on for a long time and we've had our violations, I'll give you examples. Decades now, decades and decades, they've been taking homes, foreclosing on homes from individuals. That's not lawful. They can't take your land from you without these seizures, high crimes and misdemeanors. That's the stuff you need a grand jury indictment. They can't just steal your property. This is what they're doing. They're meant to protect it. But like I said, we have things backwards. This whole foreclosure thing's been going on for a long time. And when that becomes, when they find out that there's fraud involved with the whole loan issuing thing, and they're literally stealing from you and they're being paid multiple times over, it's disgusting practice that all of these banks are involved with. Every one of them that does any type of loan. But when it comes out that that's criminal, many people that have lost their homes won't be able to get them back. New individuals live there. There's other things that they've lost. They cannot be fixed. This is accounting for that. But that doesn't mean that there isn't damage. And if there's damage, there's a remedy. So while you can't get your house back, you most certainly can liquidate that bank and sue them for 5 times the damages or more and get reparations. There's a lot of protection we have under the common law. People want to say there's no accountability for vaccine manufacturers. Of course not, under the statutes. But you sue a man in that company or that company under the common law, and they can't stop you. We just don't know better. And if we had grand juries, we can indict these organizations. We can investigate these companies for criminal practices. We can investigate the government for criminal practices. And when it's discovered with probable cause, indict them. They get pulled from office and tried for crimes. That's how it's supposed to function. But it's the people that have to do that. And these people that are ruling us, these enemies in charge, they're not going to tell us, and they're not going to really make it easy for us to do that. We actually have to learn and enforce it.
I want to interject something, because while you were talking, I looked up what states have grand juries.
Mm-hmm.
And they are Alabama, Alaska, Delaware, Florida, Kentucky, Louisiana, Maine, Massachusetts, Minnesota, Mississippi, Missouri, New Hampshire, New Jersey, New York, North Carolina, North Dakota, Ohio, Rhode Island, South Carolina, Tennessee, Texas, and Virginia and West Virginia.
Now, is that for federal grand juries?
I just typed in what states have grand juries.
Okay.
We have had grand juries before. I don't know if it's like a standing thing, but I remember them convening several times in my lifetime.
Yeah, I might be mistaken, but the gentleman, I was just talking with a gentleman who was trying to recruit for the John Birch Society. And when I was talking to him about these things, I said, you know, what we have to do is get a grand jury in every county in Washington and start indicting criminals in public office for violating their oath of office and committing treason. And he's the one that told me, well, we don't have grand juries in Washington. And I was kind of appalled by that. But every county has to be able to have grand juries enacted, because there's different levels. But in the county, the highest level of law enforcement in the country is the sheriff. You know that, right?
Yes,
Right.
and most of them don't know that.
Right. That's, again, we're not taught how our government's supposed to function. But they're the in scripture, they're the leader of thousands, the rulers over thousands.
I've tried to tell our sheriff that umpteen times, and
That's literally, it's the highest position of non-named position of authority in government is the ruler over thousands. And in the common law vernacular, that became known as the reeves were the rulers over the thousands, but the shire reeve was the ruler over 1,000. That became the sheriff. And they're the ones that were endowed with the authority to do these things. It started off literally from the scripture. They're the judges that the people would go to. You had the rulers over tens, and then the rulers over 50s, and the rulers over hundreds, and the rulers over thousands. And that is what the office of sheriff culminated into.
well, our county health guy is trying to enact these back passports, and I told our sheriff that he needed to put an end to it because he's the highest authority, and he just kind of ignores me.
Now, see, if you write him a letter and say, hey, look, this is a violation of the Constitution. You have X amount of time to do your duty and not be in violation because I want it to be timely handled. Or call him and put him on notice that he needs to take care of it. And then if he doesn't, that's grounds for an indictment. He's now dereliction of duty. But you actually have to put this on them, make the onus on them to do it. I tried calling, see, this is my problem. I really don't, I'm new to these things. I sound like I know a lot because I retain information well. But I'm new to all this stuff. I've never put any of it into practice. I tried calling my local sheriff and sharing the information about the court case in Alberta. Not so much the ruling of it. They use sophisms. They use Jesuitical word games to try to trip you up in things. But I was trying to show them that, look, there is no separated or singled out SARS-2 virus in existence. This whole thing is based on a false premise and it's unconstitutional. But I didn't even get the chance to speak. The gentleman hung up on me. He was rather rude.
Oh, geez.
And this is the sheriff's department. So there's things that can be done. He's literally just committed treason in that very act. But I'm not trying to get him in trouble. I just want him to do his job. If he won't, then I want to get him out of there so someone will that's not a coward or a criminal, right?
So the only way they're getting away with all of this is because there aren't grand juries?
The only way they're getting away with this is because we, the people, are ignorant.
Because I know a couple that lost their home to the IRS.
Yeah.
I mean, they came in there and literally kicked them out of the house and locked them out of their house.
And that's
And
because
they took their house and all their possessions.
And it's completely because of ignorance. It's as simple as he could have fixed it with sending them a rebutted contract, or you can go to literally take them to court and cancel the debt, discharge the debt in court because it's a banking transaction, and you can just do it with your signature on a piece of paper. We just don't get taught these things because criminals, Jesuits, Freemasons, people that don't have our best interests at heart, that really hate us, are in positions as public servants that they're usurping as authority figures, right? But it's literally ignorance. If we knew better, this stuff wouldn't happen. Not only would we be united against every usurpation against our rights, but we would be able to stand up to this stuff lawfully.
Tell me what the source is that you've been, that you just said a few minutes ago. I'm going to tell Adam about it so he can start studying this. Constitutional something?
Yeah, urlaw.org. That
The letter U and the letter R?
No.
Or YOUARE?
YOUARELAW.org. That's the gentleman's YouTube channel. That's his website. That's their ministry organization. He does the most simple work on the contracting, on not even going into the courts to deal with it and to fixing these things before you have to go to court. You'll want to go learn about that. It's like it's Carl Miller's stuff that he was doing, but streamlined. And it's a little more proactive. You're not waiting to be in a defensive position. You're on the attack, basically. But it's very what I've seen from it so far is pretty amazing. I want to learn more. I'm watching those as I have. I'm reading what I can, but I've got so many things I'm doing. It's while I have opportunity, right?
With
Anyways,
your free time.
yeah. We got to finish this real quick. It's 8:24. This one's section 258. It says, on the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Section 260. Although it is manifested that an unconstitutional provision in the statute is not cured because it is included in the same act with valid provisions, and that there is no degrees of constitutionality, meaning either it is constitutional or it's not. It's either a law or it's void. There is no in between. This is another court ruling or court case, judicial decision here in 1943, Murdoch versus Pennsylvania. And it was stated that a state may not impose a charge for the enjoyment of a right granted by the federal constitution, and that a flat license tax here involves restraints in advance the constitutional liberties of press and religion, and inevitably tends to the suppression or to suppress their existence, that the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. That's driver's license, hunting license, fishing license, boating license, any license. They don't have the right to do that. You don't need a license to do any job. You can get one if you want to, but you don't have to because it's your right to contract however you please. Shuttlesworth versus Birmingham, 1962. If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage the right with impunity. And they can't, this is if they try to say you're willfully being violators of the law. The United States versus Bishop sets the standard for criminal violation of willful intent. Number one, it must be proven that you are the party. Number two, it must be proven that you had the method or opportunity to do the thing. And number three, it must be proven that you did this with a willful intent. Willfulness, the definition, is an evil motive or intent to avoid a known duty or task under a law with a moral certainty. And then it says here, now since the prosecutor does not have a clause of action for which relief can be granted, Your Honor, may it please the court, this is what you would say to them, right? May it please the court, counsel is, or if it may please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the court at this time, I would motion most graciously for a dismissal of or with prejudice for failure to state a cause of action for which relief may be granted by this honorable court. and I would like to collect my cost and fees for having to defend this frivolous complaint, sir, if it may please the court. So this is what you can say when they can't have a remedy because there's no cause of action, when there's no jurisdiction, or when they don't have they don't have anything that applies to you. There's no cause of action that can be granted for relief. You ask for it to be dismissed with prejudice, meaning they can't come after you again. And then you can actually collect your fees for winning your court case, because if you win, you get paid. If the prosecutor wins, he gets paid. But if you win, you get paid. Did you know that?
So is this saying that building permits are not illegal?
That's right. You don't need a building
Oh,
permit.
brother.
Not on your own land. You don't need permission from anyone to do anything.
Adam was not able to build his house that he built on my back garage the way he wanted to build it because the neighbor next door went to the hearing we had to have and complained about it. So we wouldn't even have had to have the permit in the first place. He would have had no say in it.
That's right. You don't even need a permit. You can just, with impunity, do what you will on your own land.
I
As
know
long
that-
as you're not
I know
violating
that-
anyone else's rights.
That's definitely true if you live in the country. I know that some cities have differences in what you can and can't do.
Yeah,
Well, we
well,
live
see,
in the city, but
city law, that's Roman canon law. That's not applicable for man. That's applicable for their lowercase citizen. They will try to get you to do that. They'll try to enforce their laws on you, and they'll try to tell you, well, you live here, you have to do this and that and this and that and whatever. But that's when you have to stand up to it, because you just read, if they try to take your right and make you pay for it, you can ignore that and then do it with impunity. If they try to do something, you go to court, you take them. Where's the victim? Who did I injure? Bring my accuser before me. Where's the injured party? I'm a man. You're violating my rights. Stop doing it. Or you can, there's other methods you can do. You write them a letter, demand reparations, and give them time to fix it. Right? You watch that other gentleman's, the videos from that urlaw.org YouTube channel, the ministry there. You'll see what I'm talking about. It makes a lot more sense than I can right now, though. But
did you say the same thing too about those traffic camera things?
Yeah, see, a traffic camera is not they can't witness on a stand. You call your
So
accuser
Adam
a
has
witness.
gotten 2 of those and he just totally ignored them and nothing's ever happened.
Right, because, well, see, ignoring it, they'll put it on your record. If you just return that, say dishonored or no contract, then they can't do anything. Or if you can put that, before we can continue, right? Show me where you have jurisdiction or authority to do that. There's lots of different things you can do, but usually with the traffic ticket like that, you just write dishonored or no contract and send it back, and they can't do anything.
Well, he never did anything and then nothing's ever come of it.
Right. It might be on his driving record. You might check with that, but it might be nothing.
I'm sure his insurance would tell him if it was on his driving record.
Dishonored, or what do you write on there?
You write dishonored right across the whole thing.
Okay.
Or no contract. And then I'll give you the full thing you can put on there. If they force you to sign a ticket, like on the side of the road, you just write UD UCC 1-308, or you can put dishonor right across the thing and just give it back to them. And then if you go to court for that, they look at that and they say, well, he didn't agree. So then you go away and there's no problem. But right here, Owen versus Independence, 100 volume Supreme Court reports. This is from 1982, right? The right of action created by statute relating to deprivation under color of law. If you guys don't know what this is, deprivation of your rights under color of law would be like a police officer searching you, taking your weapon from you because he's uncomfortable. They have a statute that gives them permission under police powers to violate your Second Amendment. That's deprivation under color of law, because anything that's repugnant is void. You see how that works? But you have to enforce it. You have to stand on your rights. So right here it says, the right of action created by statute relating to deprivation under color of law of a right secured by the Constitution. And that's all of them that are written and all of them that are not written. And who gets to decide what your rights are? You do, because you're the people. Your rights are what's given to you by your creator.
Say that again one more time, how you're supposed to sign a ticket. You see what?
If they compel you or they say they're going to take you to jail unless you want to fight this and go in, you could do that too, because if you record this and you make a note of every violation, that's a lot of trouble they can get in. I'll give you an example. There was a gentleman that was detained for 28 minutes. He was not jailed. There was no fine. He was detained for 28 minutes. He sued and he got, he was detained for 15 minutes. He sued and got $28,000 because they violated his right by seizing his person for 28 minutes. So
That's crazy.
It sounds crazy, but that's because it's like the king. How dare you subject you come and take me? What authority do you have? I'm the king. That's the mentality behind it. Now, we don't act in that capacity. Everyone's equal here, but the people are sovereign. They have all the rights and privileges of a king, and these are our servants. It's their job to go out of their way to protect the rights. They swore oaths to do that, and it's a death sentence when they violate that. This is the power that we don't know exists in this country, and it's really the people's power. But if we
Okay,
don't
tell me
enforce
that
it,
again. Tell me what you're supposed to write again. UCDD or
Right.
something?
Yeah, so you write UD, it means under duress, or you can skip that part, but you would write UCC 1-308, and then you can write without prejudice. You either put the UD or you put the without prejudice, one or the other. Usually, if you're signing a contract, like if you're signing the back of a license for a driver's license because you don't want to deal with being pulled over or whatever, or you need identification or for whatever reason, if you're just getting an ID card, if you're getting a passport or whatever, and you're signing a contract, any government contract, doesn't matter what it is, you sign UCC 1-308 without prejudice. You reserve all your rights. You don't contract. You don't agree to anything. If you're being compelled to sign like a ticket, or they're forcing you to do something with your signature right there, you just write UD for under duress, UCC 1-308, and that voids it. That means you don't agree to anything.
My driver's license expires on my birthday this next year. And I was thinking about not even getting anything, but there are some times when I need a photo ID, so I don't know what I should do.
There's ways around that. You can get some otherwise too. Stuff to go over in a later time, I think, but I gotta find out how much we have here. Just one moment. All right, so right here it says, the right of action created by statute relating to deprivation under color of law, which I told you what an example of that, right? Of a right secured by the Constitution and the laws of the United States, and comes claims which are based solely on statutory violations of federal law, and applies to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Officers of the court have no immunity when violating constitutional right from liability. And that's judges, that's police officers, that's any public official. They don't have the right to say, oh, we have immunity for violating your right. There is no immunity. Anytime they violate your unalienable right, there's a remedy. Okay. They do so at their own peril. And they literally, if it's a public servant, they literally are committing treason, which you see right here, Title 18 U.S. Code Section 241 and 242. If upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. And it's also, the penalty can be death. It used to be you would be hung until dusk at sunset. It says clearly establish the right to sue anyone. This is Title 42 U.S. Code Section 1983, 1985, and 1986. It clearly establishes the right to sue anyone who violates your constitutional rights, the constitutional guarantees, which are those that are written and those that are not. All of your rights. He who would unlawfully jeopardize your property loses property to you. And that's what justice is all about. And if you remember the common law, what's the law about a thief? If a thief gets caught with your goods in hand, he repays what? Double. If he sold it, then it's fourfold or fivefold, depending on the quality of the goods, or depending, right? It was the you take the principles of scripture. They had lambs or sheep and oxen, for example, but you apply it in the method it's applicable in common law. And that would be with a jury of your peers upholding what they know to be true, right? But right here it says judge or officer or public servant XYZ, you are deemed to know the law and are sworn to uphold it. You can hardly claim that you acted in good faith or willful deformation of a law, or for willful deformation of a law, and you certainly cannot plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street cannot claim ignorance of the law. Therefore, there is no judicial immunity. All right. Right here, Breyers versus the United States, the constitutional provisions where the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen, capital C, and against any stealth encroachment therein. Now, these criminals are actively not only not watching for it, but actively encroaching themselves. That's why we can't just go in there. You have to be with groups. You have to be with the people supporting one another, because it's the militia, who is every able-bodied man, that enforces the law, which is the Constitution. That means it's my job, it's Hugh's job, it's every man's job to enforce this. It's our duty to do so, and it's because it's our country.
So we have to have militias. I'm sorry to interrupt. We have to have militias first, right? Is that what that? Okay.
See, the Air Force. I love my country. I was in the Army, but the military industrial complex, the Army, the Navy, the Marines, the Air Force, this new Space Force farce that they have, none of that is lawful. All of that is repugnant to the Constitution, because our country has the militia. It does not have a standing army.
Boy, I wished Adam would have known all this when he got that ticket in that little town. He could have had a field day.
I know. You know, if I'd known better, I could have talked to him. He would have been able to walk into that court and devastated them. I mean, completely owned them by just not giving them jurisdiction. I'll show you. I sent you that video, right? I'll send you a video. There's this gentleman. They got arrested for illegal concealed carry without a permit and resisting arrest. Both of them, which could be punishable with up to $10,000 fines and 9 months in prison each. And there's another offense as well. And they just did not. They didn't agree to be a sir or any titles. They said, I'm a man. I don't understand what you're saying, which means that you don't stand under their authority. In legalese, when you say you understand, if the judge tells you something, says, do you understand? If you say yes, then you're submitting to their authority in legalese, because it doesn't mean that you comprehend, but it means that you stand under their jurisdiction. So that's one way they get you. But he said, I don't understand. I don't comprehend your language. I only speak man to man. With just saying those three things, now they could not, he removed themselves from his jurisdiction. They could not contract with him or verbally get him tripped up like they were trying to, because he claimed to be ignorant. If you claim to be ignorant or an idiot, or like he had said, to not comprehend their language, which, if you remember, if something's all capital letters, that's called hocus pocus. That is not that's not English. That's a language that someone defines the meaning of themselves. It's an occultic language. It's a hocus pocus language that not everyone knows the meaning of, and it's not admissible in any court as a binding contract, which is every paper that the government gives you. Hocus pocus. So if you know these things, you can literally have a roughshod over them, and they can do nothing. But it's becoming familiar and knowing what you're talking about. You don't have to know their statutes. You just have to stand on the common law and not be sinning.
Well, the things they did in that court were so messed up, and Adam could have really had a field day if he would have done this stuff.
Right. What they're doing is admiralty law. It's not a common law court. It's admiralty law, and he gave himself under their jurisdiction so they could do what they wanted.
This was more like a Mickey Mouse court.
Yes, it's literally the judge can make their own rules, and it's arbitrary. They can have a jury, but the judge is the final decision on what you're punished, regardless of what the jury says, under the admiralty court system, because that's Roman canon law. That's
one thing
law.
Adam did tell him. He told him he wanted a jury, and they said, we're not doing a jury for this.
Yeah, see that. Then he should have said right there. He should have realized right there something was wrong. But there's ways out of that. At any time, you can question jurisdiction even after a ruling. So if he's already had a case been decided, he can rebut the jurisdiction.
He pleaded no contest, and he already paid the fine.
Next time, well, he should watch those things. You share it with him, but
I will.
If it ever happens before he does, you don't plead anything, because you don't even get to that step. You say, before we can move on, I need to say, where's the victim? Where's the injured party? I'm a man. I need to face my accuser. And so you're pulling yourself out of that jurisdiction. They can't contract with you that way. It's all about them getting you to admit that you're under their authority, that you're their statutory citizen, that you have to follow the rules. But if you don't say that, if you stand on being a man or a woman and you keep it simple, you don't answer the questions, you ask them questions, you keep it on their, they're having to prove that they have jurisdiction. They can't, and then they have to let it go.
He started studying a lot of this stuff, but I don't know why he stopped, but he needs to start doing it again. Because one of the things is, he does tell him, I don't answer questions.
Mm-hmm. That's good. All right, so here, I want to finish this page, and then we'll have to stop for now, because I really have to get going. We'll finish this. It's almost done, but we'll finish.
Oh, I'm sorry. I thought we already stopped.
No, it's, I think we're still recording here. Yeah. So here we go. It says the constitutional provisions where the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealth encroachment therein. When a federal officer participates officially with a state official in a search, so that in substance and effect it is in their joint operation, the legality of the search and the use in evidence of the things seized is to be tested in federal persecutions as it would be if undertaking were conclusively the federal agent. All right. So, but the point was that they're bound to protect you, and they're actively working against that. It's treason on their part. And then right here, the last one for the page here, this is Boyd versus United States. It says, the court is to protect against encroachment of constitutionality or secured liberty. It is equivalent to a compulsory production of papers like driver's license or registration, to make a non-production of them a confession of the allegations which is pretended they will prove. The seizure of compensatory production of a man's private papers to be used in evidence against him, like a driver's license, which they look it up to see if you have any warrants for your arrest or any criminal activity that they can hit you with. That's illegal. All right, they can't do that. You can say no. You're required, if they suspect you, if they have reasonable articulable suspicion that you have been, are, or will, like are in the process of committing a crime, then they can ask you to identify yourself. But they can't force you to give you a paper, a license, or anything. You could tell them your name and address. That's all you have to do. But it says, or not even the address, really, just your name. It says the seizure of compensatory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself, violation of the Fifth Amendment. And in the prosecution for a crime, penalty or forfeiture is equally within the prohibition of the Fifth Amendment. Meaning, if they compel you to, they force you to, and they seize your paper, they've now violated your due process. And if you remember, they lose jurisdiction. But we have to uphold that. And it is not the court's decision to say, well, we think that this is a reasonable infringement on your liberty, or it's not an unreasonable search. That's not it's not their place to say that. We get to decide. We, the people, did not dictate that they get to decide what's a reasonable or unreasonable search. That was respectively left to the people. And it's our rights that we get to determine whether they were violated or not. Right? Right. Yeah, this one right here, the Miranda versus Arizona. We'll do that real quick. It says, where the Miranda warning the police gives at arrest comes from, refuse to say anything without a lawyer or assistance of counsel present. Do not ever sign a statement that you have been told of your rights. Keep your mouth shut. You never sign statements about your rights, because that's that you're giving them up. You never give up your rights. But this is in the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges. See, the Fifth Amendment rights must be observed. The person in custody must, prior to interrogation, be clearly informed. And custody, a custodial stop is a traffic stop. So if they pull you over on the side of the road, that is a custody. If they don't do this, they violated your due rights. But here, let me read it. It says, prior to interrogation, they must be clearly informed that he has a right to remain silent and that anything he says will be used against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer, to have a lawyer with him during interrogation, and that if he is indignant, a lawyer will be appointed to represent him, meaning if he can't afford it. If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease, meaning they can't keep asking you questions, but they'll try and probe. And when they do, they're now violating your due process, which means they lose jurisdiction. Even if they had it, they lose it. If they didn't have it, they never had it, and they still won't have it, but they'll even have it less if that's possible. So it says, if he states that he wants an attorney, The questioning must cease until an attorney is present or assistance of counsel. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Where the individual answers some questions during interrogation or cuts the interrogation, he has not waived his privilege. It's not a privilege, it's a right, and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are, in the absence of a fully effective equivalent, prerequisites to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation presses required for the protection of the individual's constitutional rights should not cause an undue interference the proper system of law enforcement or with the proper system of law enforcement as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. And here's the important part here for us. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate or abolish them. Okay.
So what happens when you do this and it just makes the cop mad and all he does is just arrest you?
Then he's violating your rights. That's a
But
lawsuit.
that's not stopping him from arresting you.
No, but see what he's doing is criminal now. He is no different from kidnapping. And when all that's done and he takes you there, you don't sign anything. You say, I want to speak to the judge. I want him put on trial and charges for kidnapping, violating my due process. This is criminal charges. I'm letting him know. You warn him verbally that you're a man or a woman, that you're standing on your rights and that he's violating them. You don't need to be angry or act contrary, but you let them know and you record it. Then you write down every violation and you make a criminal complaint against them and you sue. There is no limitation on damages for a violation of your unalienable right. These are given by your creator. There's no price limit on that. And people can literally get millions of dollars if they do this correctly. Although I'm not trying to get millions of dollars out of the system. I'd want to break that system and make them. I would demand a jury trial. I would demand a court trial. I would not settle out of court. And then I would make it where it's ruled in court that they are required for everyone that is a public servant to learn to protect the rights of the people. Right? You can do that. And they can't stop it. The only thing they can do is try to kill you.
Yeah. That happened. Well, they didn't kill him, but that happened to a guy that witnessed an accident and they were messing with him and he tried to tell him that he wasn't doing that and they beat him up.
See, that's why we have the people are the ones that have to enforce the law, and the people need to realize that we're required. It's our duty. We need to be armed. We need to be educated. It really is that simple, because we have a massive amount of individuals in this country that are serving Satan through a variety of means. Call it Catholicism, call it Freemasonry, call it open witchcraft, which those are existent too. They serve Satan, and his objective is to destroy this nation and the people in it. All right,
Yep.
so I'll finish this real quick because I really got to hurry though. But just because we're almost done here. It says this is Norton versus Shelby County, right? An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. The court follows the decision of the highest court of the state in construing the Constitution and the laws of the state, unless they conflict with or impair the efficacy of some principle of the federal Constitution or of the Constitution, or of the federal statutes, or rule of the commercial or general law, the decision of the state courts in questions related to the existence of its subordinate tribunals and eligibility in elections or appointment of their offices and the passage of its laws are conclusive upon federal courts. While acts of de facto incumbent of an office lawfully created by law, an existing or often held to be binding form reasons of public policy. The acts of a person assuming to fill and perform the duties of an office which does not exist can have no validity whatever in law. So that means the TSA has no validity whatever in law. It's a violation of it. There's many other things that do that too, that we have to stop. All these alphabet soup organizations, they have no authority to create them. We didn't give them the right. And they're actually used against us. The CIA's the Jesuit spy organization that's used foreign and abroad. The FBI has been used for decades now to federally cover up crimes and take the jurisdiction out of local hands. It's criminal. We have to become aware of these things and put a stop to it, though. This is U.S. versus Doherty. States, it's said, the jury has an unreviewable and unreversible power to acquit in disregard of the instructions on the law given by a trial judge. U.S. versus Mullen, we recognize as appellants urge the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge, meaning the statutes. The jury has the right to judge both the facts of the case and the laws in question. This is part of the Texas state constitution. The reason why they put this here is because it's in the constitution that a privilege or immunity of any citizen of any state is the privilege and immunity of every citizen of every state, because we're all equal. So anything that helps a citizen in any constitution helps them all if we know about it and we assert it. Again, it's on us to enforce the law. But right here, the Texas Constitution says, no citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised, except by the due course of the law of the land, which means due process of law under the common law, which is the law of the land. And this is Texas state law on larceny and extortion, which would be applicable against these criminals that are in office. Creating or confirming by words or conduct a false impression of law, like a mandate that has no force of law. That's it. That's extortion. That's larceny, and that's criminal. This is creating or confirming by words or conduct a false impression of law or fact that is likely to affect the judgment of another in the transaction. So all these mandates are literally against the people. Anything that's making them like they're going out and buying these face masks if you're spending money on it, or you're having health issues because of it. And for anyone that might not know, this Jesuit trained Dr. Fauci, who's in charge of this fiasco, who is also in charge of the cure for AIDS victims that was killing them because he's a Jesuit. These people, you should read about their fourth oath of induction. But he,
he's pure evil.
Yeah, it's pure evil. But he wrote a paper conclusively showing that more people died from bacterial pneumonia from those face masks and breathing in their own filth than they did from the Spanish flu. And this is known by him personally, and they mandate these things because they're not having your best interests at heart.
No, they're trying to kill us.
There is a doctor who put together a paper where there's 17 medical journal entries about the harmful ways these masks can be affecting you. So it's not beneficial. These things are not for our benefit in any capacity. At the very least, they're getting you to submit to being a traitor to your country, because you're submitting to the authority of another and not to your creator. But that was the end of this one. I think we finished it here, so I'm happy about that. Thank you all for your time. And then we will continue with the Citizens Rulebook next time, I think. Okay.